Yes, Mr. Georgy.
So, well, we've been busy. I'm not sure how productive, but we have been busy over the short adjournment. And there's two documents we've handed up on our side. One is the relevant chapter of Foskett, the 9th edition, chapter 5, which I'll come to in a second. And the second is one of the authorities referred to in there relating to construction, but not implication of terms. And of course, they are different processes, as made clear, amongst others, by Lord Newburger in Marks and Spencer. So if I just take those documents in turn, and then there is one other document which has come from my learned friends, which is Vneshprombank, decision of the Court of Appeal in 1994, and haven't had a chance to look at that, so not quite sure where that takes us. But anyway, I understand that they're going to want to refer
used to be
that.
A jolly popular authority in the old days.
So if I could start with the Foskett section, and
I think it does say, doesn't it, that the court will imply it.
Well, there is a reference to it in relation to implication of a term's time, but with no, it doesn't seem to be with any actual authority to support it. So we're just taking it, if I can, a little slowly, starting at 536. That's 5-36. Relevance of jurisdiction of court when construing consent, order or judgment.
Have you got an electronic copy of this?
I think one's being sent over actually,
okay.
to your clerk as we speak.
It'll come over when it gets sent out.
Yeah.
536.
Yes. So a general approach to the construction of a consent or judgment is broadly the same as the construction of a contract of compromise. And then there's reference in the footnote to Cirrus International 2004 House of Lords, and then also at the end of that footnote to Court of Appeal in Weston v Damon 2006. And that's the authority I brought along. Maybe we could just glance at that for a moment, and then you can put it to one side. The relevant passage in Lady Justice Arden's judgment is at paragraph 5 and 6. I don't think you need to worry too much about 6. I think it's 5. That's the relevant passage, and that is dealing with interpretation.
Well, I would have thought that's all pretty obvious,
which is, yes. I accept that's fairly obvious, but in any event, that's the principle there set out. Going back then to paragraph 5-36 of Foskett, he then says that a consent order is evidence of the agreement. No objection in principle to evidence of the terms of the agreement be received to assist in any ambiguity in the terms of the agreement. Then it deals with conflicts. And then at 537, or probably just at the end of 536, I'm sorry, at page 85, about 5 lines down, he says the consent order of judgment then falls to be interpreted in a way in which an order of a judgment of a like nature, but not expressed to be by consent, would be interpreted. If there's any doubt about whether the order of judgment is within the court's powers, it should be construed as being limited to the jurisdiction of the court and enforced only to that extent. And then 537, consistent with the principle that when parties agree that a consent order or judgment should be made, they are to be taken as submitting themselves to the ordinary jurisdiction of the court. The court will approach the interpretation of the consent order or judgment by reference to the court's ordinary jurisdiction. And then there's reference to a number of cases which, I have to say, looking through, did not appear to be relevant, but I do note that at 541 over the page, there is a reference to the Falk case, which, as I say, my learned friends have brought along. So perhaps I'll just invite the court to read. It goes over to the next page.
The summary. Okay. Yeah.
That appears on, certainly on the commentary, to be concerned with the construction of the order rather than the implication of terms. So
which the claimant ought to pay. I mean, it all turned on it saying in the order it was agreed that they should determine damages which the claimant ought to pay.
Yes.
So presumably they can determine whether the claimant ought to pay them.
I suspect that's, well, that is part of the reasoning.
That would seem to be the point.
The wording, as said in the third of the reasons of Lord Justice Goldham, is that the wording of the undertaking in order is capable of including the exercise by the court of its discretion. So that doesn't
is reflected in the head note. Yep. Okay.
And then we've got implied terms, which is dealing with implied terms generally rather than court orders, but there is some reference to it in the context of court orders. So at 542, this is just the general position. Parties may omit to include in their agreement a term which is necessary to render it effectual or complete. In these circumstances, the court will imply a term to render the agreement effective or complete. And then we've got some familiar authorities in the footnotes at 84, 85 and 86, which are clearly just the general principles that we're all very familiar with. And then at 543, implications as to time. And again, at this stage, it's talking about an agreement, a contract rather than the order, unless an agreement expressly provides that an obligation is to be fulfilled within a specified time or can be construed as such. A term will be implied that the obligation must be fulfilled within a reasonable time. And then I think we can skip the next sentence. And then at 544, consistent with the approach referred to above, where parties agree to an order or judgment, they'll be taken to have submitted themselves to the usual rules and jurisdiction associated with such order or judgment, unless they've agreed otherwise. I think that's fairly obvious. If they've agreed otherwise, that will ought to be apparent from the terms of the order, but there's no agreement to the contrary reflected in the judgment or order. A consent order or judgment for the payment of a sum must be complied with within 14 days, so that's the automatic operation of CPR 40.11. A consent order requiring an act to be performed must specify the time. Under the previous rules, the judgment entering default, which did not specify time for compliance, would be set aside. And then over the page, the original order treated as a nullity. Under the CPR, failure to comply does not invalidate any step taken. The practice in relation to the enforcement of mandatory orders has not changed. The antecedent agreement failed to contain an express term as to the time of performance of the obligation to be set out in the consent order. And this is the only relevant passage I think I've found. The court would imply an obligation to perform the obligation within a reasonable time. And that footnote 97 in support of that refers back to paragraph 543 on the previous page. The only relevant bit in 543 is in the first sentence, the second line, a term will be implied that the obligation must be fulfilled within a reasonable time. There's then a footnote for support of that is Chitty Volume 1, paragraph 21-021. That's not a current reference. It's not hyperlinked in Westlaw, and Chapter 21 is dealing with something I think it's illegality. The Shears case isn't. I looked on Chitty and I couldn't see the Shears case referred to. It is referred to, I think, at para 3-23, as noted here in Foskett, and on initial review of that page, it appears that's just simply a contract case rather than a court order case, so it doesn't provide any assistance at all. I do caveat this by saying this has been done in a bit of a rush, but that's where I've got to in relation to that. Going back to where we were at the end of 544, which is on page 88 of this, what it goes on to say in the sentence, which it's part of the way through, court would imply an obligation to perform the obligation within a reasonable time, and alter the order accordingly upon application. So it appears this is some sort of correction of the court order, and that would be understandable because the court order should express the terms. Unlike a contract where you can imply terms, there is a requirement for court orders, including consent orders, that they should record the terms agreed between the parties. And that may be a point of distinction. And then it's under permission to apply, it deals with the question of whether the consent order includes permission to apply or not. In 544, you can see that if it is included, it enables the court to make further orders for the purpose of working out the order. And if the parties omit the expression, then would the court imply and entertain an application as if it had been expressly reserved? And then it says, in case of orders which are not made by consent, which are not of a final character, it's clear that words will be implied. This is into normal court non-consent orders. And permission, if given, if appropriate, to amend the order under the slip rule. And they say, excuse me, again without authority, that there seems to be no reason in principle why the same should not apply to consent orders of a similar character. And then they say the implication of such a provision in the circumstances indicated should not be confused with the question of whether the expression might be implied where the parties agreed to stay proceedings upon agreed terms, but omit to provide for it in relation to enforcement of these terms. It's clear that if the stay imposed consensually is absolute and unqualified, skipping the parentheses, and no permission to apply is reserved, the court will not imply such a provision into the order. If it's qualified in the sense indicated, but the words permission to apply are omitted, would the court imply them on the basis of the approach discussed in the preceding paragraph? There's no reason in principle why it should not. It would merely involve the addition of a term to the agreement reflected in the consent order, which is necessary to render it actual or complete. And then there's a reference back to 542, which is the introductory paragraph to the section. Excuse me. So that, I'm afraid, is the extent of the research on those points.
You say what?
Well, what we say is sort of bringing that all together is as follows. First of all, that there is no clear authority to support the proposition that the court can imply terms as opposed to imply terms into an order in the same way that they can for an implied under an agreement in relation to consent orders. There is reason to see why there would be a distinction between the two in relation to implication of terms as opposed to construction of an order. And principally that concerns the need for an order it being an order of the court to reflect all the terms, so that there is clarity as to what the court has actually ordered. And consistent with that, I note that the practice direction 40B at paragraph 3.4, that's page 1421 of the volume 1 of the White Book, says a consent order or judgment must be, 1, drawn up in the terms agreed. I think that just goes to emphasise the...
Must be drawn up in what?
In the terms agreed.
I'm sorry, so that's page 1421.
Yes, of Practice Direction 40B, at paragraph 3.4.
Well, that doesn't seem to say very much.
Well, I think it just gives me some support for the proposition that there may be reasons to make a distinction between implication of terms in a contract and implication of provisions in a consent order.
Right.
That's the first point I make in terms of whether the principle applies for implication at all. Secondly, I do I do focus on the fact that the implied term argument is not one that was advanced either in front of the master or in front of the judge, and this is of course a second appeal, nor is it raised as an argument in my friend's skeleton argument or grounds of appeal. And if I could just take
you don't need to make that good because we know, but it could be said, couldn't it, to be the substance of what he's saying, even if it's not expressed in that way, because he has said time and time again, I didn't get what I bargained for.
Well, it's been put in his...
which implies that the bargain was something different.
Well, the way that, if you'll just bear with me for a moment, I'll just take you to his skeleton argument. So it's at Bundle 1, tab 3. The relevant ground is ground 2, which starts at page 16, paragraph 45.
Paragraph 45 of the appellant's skeleton.
Yes.
Yeah.
That's the start of the submissions on that ground. Mm-hmm. Paragraph 46, in compromising the application, bank guarantee application, GB agreed to accept a guarantee in the form set out in Schedule 1, objectively interpreted they agreed to accept a guarantee. So this was quite clearly being put on the basis of construction rather than implication of terms. Mm-hmm. And to a similar effect, at the end of the next page, paragraph 48, at the foot of the page, 4 lines from the bottom, properly construed, GB did not agree to accept a guarantee accompanied by an advisory note, etc. So it's quite clearly being put on the basis of a construction.
Well, whilst the modern law is that implied terms are different from interpretation, the Baylis case said something different.
Well, yes, but in terms of the applicable principles, well, first of all, Marks and Spencer's makes it clear per Lord Neuberger that they are different processes governed by different rules, construction and implication, and as noted by the Master of the Rolls and Phillips electronic, the implication of terms is altogether a more ambitious exercise than the construction of terms, because it's dealing ex hypothesize with matters which the parties have made no provision. So one is dealing with different principles applying, and I think it is highly material that the case that's been put on this appeal is in relation to construction.
So what if they'd said, Mr. Georgy, dear Mr. Bedzhamov, we will not pay if we are sanctioned or if there is an argument about sanctioned, and this is a term of the guarantee. Would he have to have accepted that? The order had been complied with?
If it was a term of the guarantee, then he wouldn't have had to accept.
No, it would not be.
We would not have complied. But if it wasn't a term of the guarantee, then we've complied with the terms of the order. I mean, I think it's important to appreciate that the terms of the consent order didn't have provisions which would concern whether the quality of and effectiveness of the guarantee. It didn't contain a provision which said the guarantee shall be, as provided, shall be as good as cash. What was provided were terms that needed to be complied with. That was the parties' bargain, and as I said before the short adjournment, if the terms of the guarantee, properly construed, were in the terms of the schedule, as the judge found, then there is compliance.
What was the effect of the advisory note?
It wasn't of any contractual effect. It was a statement of advice, I suppose, but it is of no contractual effect, as the judge found, and is not subject to appeal.
So it doesn't have any legal effect at all?
No.
Why wasn't it admitted then, when Mr. Bedzhamov asked for it to be admitted?
The Standard Charter wouldn't agree.
Well, that suggests they thought that it did serve some purpose and did have some effect.
Well, the judge has found it doesn't. And the judge is dealing with this matter as between my client and Mr. Bedzhamov. She is considering whether or not we have complied with the terms of the order. She's made a definite decision on that.
Do you accept that whatever she found as between you and Mr. Bedzhamov, there's reason to think that Standard Chartered might, in certain circumstances, rely on the advisory note in order to refuse payment? There might be an argument about it. That's Mr. Fenwick's concern. There might be an argument about it.
There might be an argument anyway, because Standard Chartered might take the view that sanctions prevent it making payment, when in fact sanctions don't prevent it making payment. And that would be a matter that would need to be determined by the court. So, for example, to give the example that Mr. Fenwick gave, if they took the view that a sanction against A1 LLC, if such a sanction were to be imposed, would prevent them paying under the guarantee, this is assuming it's a sanction in the form of an asset freeze, the answer I would respectfully submit to that is that they would be wrong, because the sanctions do only apply to the assets, resources of A1, and payment under the guarantee does not involve any dealing with the assets of A1. It's an independent guarantee, which, in accordance with Article 5 of UDRG, is independant of the counter guarantee, and they would be obliged to pay. And they
So
would
how
have
do
no.
they protect themselves? How does Mr. Bedzhamov protect himself against he actually did say, I want to make sure you're going to give me a document in this form. You said Standard Chartered won't tell you what they're going to do, so get lost. And he said it again and again and again, because that's what apparently people have to do these days. And they took their chances, and then Standard Chartered come up and do exactly what he feared. And how could he have protected himself against that? What was he supposed to do to get what he bargained for, which was an unconditional guarantee without the possibility of Standard Chartered arguing in the future that they told him they wouldn't pay if there were sanctions?
Well, what he bargained for was what the order provides, and what he bargained for was a guarantee in the terms of the schedule, and that is what he's received. If as a result of exceptional circumstances he considers that that doesn't give him protection, then no doubt, as he has done as of last Thursday, he will issue his application for a variation of the order, and that will be determined by the judge. But as the order currently stands, it's been complied with.
This is a hard case, but hard cases would make bad law, you say.
Well, whether it's a hard case or not may depend on whether his variation application succeeds. But it is the bargain that was reached, because that's what the order says. And to go down other routes to try and accede to the pulling of the heartstrings could create dangerous precedents.
I think that's just what I said. This is a hard case, and hard cases would make bad law.
I apologise for putting it in my own terms, but I didn't necessarily want to accept it was a hard case. That's why I rephrased it in the way I did.
Originated with an article about the case of Harbutt's plasticine that you're too young to remember, Mr. Georgy.
I remember it was about the 1950s or 60s, but that's about it, I think.
Yeah.
It
was a very important case on interpretation of contracts in a previous era.
Yes.
Anyway, yeah.
The other point I want to make in relation to, sorry, I've got a couple more points in relation to the implication. Right? The implication of a term has got to be necessary to make the contract work, and ordinarily would need to be so obvious that it goes without saying. Though in rare cases, you don't need to satisfy both those limbs. We say that the contract works, the order works as it is, and it doesn't need an implication of a term. But even if you are to imply a term, it's got to be clear, and it's quite difficult, if I may say so, having to deal with implied terms being formulated in the course of argument, certainly when they're not being written down. But an implied term that talks about the standard chart, the guarantee being provided without any uncertainty, or without reasonable uncertainty, or without some degree of uncertainty, is in my submission lacking in the clarity that you would need.
Well, let me put this to you. What Mr. Fenwick is really saying is that the judge should have decided, by virtue of the breach of an implied term or of the consent orders or otherwise, that Vneshprombank had failed to provide the unconditional guarantee that Mr. Bedzhamov had bargained for, and had provided instead a guarantee overlaid by uncertainty and the potential for litigation.
Right, well,
that's what he's saying.
Well, that begs the question as to what is...
What does it beg the question of?
It begs the question as to what is the unconditional guarantee bargained for, because the judge has found...
Guarantee, I don't think it does, because the unconditional guarantee bargained for is that contained in the schedule.
Well, and he got that unconditional guarantee. The judge has found that the guarantee he got was an unconditional guarantee in the terms of the schedule.
He got an unconditional guarantee overlaid by uncertainty and the potential for litigation, because, as my lord has just put to you, Standard Chartered Bank is not an organisation which writes and then insists upon covering notes that are of no protection for them, or so they think. Their lawyers must have said, you must not give up this protection. So he's got a problem, Mr. Bedzhamov. What's he supposed to do?
Well, to seek to enforce the guarantee on the basis that the judge is right.
And you're going to be arguing tooth and nail that it shouldn't be enforced.
Well, I wouldn't be arguing. It'd be a matter between Mr. Bedzhamov and...
You'd be sitting there egging the Standard Chartered Bank on, because otherwise the 4 million comes out of your pocket ultimately.
Well, I would think, respectfully suggest that Standard Chartered Reform, it's not the bank with which my client is the customer.
No.
Doesn't have any customer relationship with them.
No, but there's a counter guarantee from Credit Suisse, and presumably your client has given Credit Suisse an indemnity. Ultimately, the Standard Chartered Bank are not bearing this 4 million out of their own pocket. They're going to bear it out of your pocket if they can.
Well, they may assume that they will. Obviously, they assume they would recover the money from Credit Suisse, but they've entered into an obligation which requires them to perform irrespective of whether or not Credit Suisse performs. I mean, it comes down. I'm afraid it comes down to the question that the judge needed to and did make a view, form a view as to whether this guarantee was qualified or not. She's found that it was unqualified. And in those circumstances, he has got an unconditional guarantee on the basis of the court's decision.
I think that's the main point. We have to decide if it's right or wrong. Yeah. Well, anything else?
No, I think anything else? No, just a moment.
Yes, of course.
No, unless there's anything else that I can assist you with, those are my submissions.
No, thank you very much, Mr. Georgy. I've never known a case where counsel is so keen to sit down.
I'm quite happy to stand up if you want me still too.
Mr. Fenn.
I'm sure that wouldn't be applying to me. My lord, of course, hard cases make bad law, but good law can resolve hard cases.
What we need from you is to know whether that formulation that I put to Mr. Georgy is in reality your case, and if not implied term, what is it? If there is anything else.
My lord, I understand that. In my submission, it is, and I know that normally the division between implied terms and constructions is clear, but this is a case in which, in my submission, both construction and implied terms lead to the same answer. The learned judge had to conclude, Mr. Georgy said, whether or not the guarantee included the advisory note, found it didn't. But she then had to go on and to consider the construction of the consent order. And the consent order was, as I've indicated, an order which provided for an unconditional on-demand guarantee. Now, I don't accept that we haven't put this argument. We may not have put it in exactly those words, but ground 2, which is in core bundle at tab 2, says the judge was wrong to find he'd been provided with a guarantee in the form contemplated by the consent order. Provision of the executed bank guarantee with a so-called advisory note was a substantial departure from the parties' agreement to the form of security. Should have found it agreed to accept a standard form bank guarantee, which would in all likelihood be honoured without any reasonable challenge. And we say that as a matter of construction, what was stipulated for was a standard bank guarantee unaccompanied by any question. And your lordship has seen, because I took you through the dreary correspondence, how concerned we were to ensure that the precise wording of the guarantee provided gave us the protection sought, with provision for us to challenge it if it didn't. And that's on the basis, what we were looking for was exactly what you put to Mr. Georgy, which is an unconditional guarantee which will be honoured on presentation. Indeed, I didn't show it to you, but later on in the bundle, page 41 onwards, 40 onwards, is our riposte as soon as we got this document, saying that it is not the unconditional guarantee which was stipulated for. And we say that as a matter of construction, first of all, the court can conclude that what was agreed was a standard form bank guarantee, pure and simple, unadulterated by additional declarations and representations and caveats. We didn't get it. Therefore, as a matter of construction, what we got was different. Now, if that's not right, exactly the same argument goes in relation to an implied term, because if you try and make the implied term express, it would have to be an agreement that the guarantee should be provided and nothing else. Well, nobody was expecting anything else, nobody anticipated anything else, but that was what we got. So the implied term is that the guarantee will not be accompanied by this additional document, which we refer to in ground 2, paragraphs 2 and 3. We know from Vosket that the court can imply terms as a necessity, and this would make no sense as an agreement without such a term, whether you take it in as a construction of what the parties agreed, or whether you take it in as an implied term, that it would not be watered down by something else to have exactly the same effect. This is not a pleading, it is a case of why this guarantee with its advisory note does not amount to what we consented to, which was something which was going to be unconditional and enforceable, as the correspondence shows. And we didn't get it. So whether you do it as a one of construction or one of an implied term, that it shouldn't be anything different. In a sense, we reach the same result. And I just want to put this point to the court. If we had been asked to agree a standard form guarantee and tell this is it, executed copy, this is what you're going to get, and we had agreed it, and then got something different, namely that and something else, there would be a departure. If we'd been given that plus the advisory note, we could reasonably have said to the court, no, we won't accept that. We won't enter into a consent order, which gives us this additional uncertainty. And in my submission, if the court had been asked to decide it, if it had been executed copy, pure and simple, the court would probably have ordered the bank guarantee could stand as substitute security. And if it had been this mixture of documents, the court would, in my submission, certainly have said, no, go back and take it away, because this is giving all the uncertainty which the guarantee is meant to avoid, and is not something sufficient to make it reasonable for Mr. Bedzhamov to agree to release the money from court, nor for the court so to order. So in my submission, it is encapsulated. If I should have put it as an implied term, then that's my fault. But when I'm trying to express the term, the best I can come up with is we agree to this guarantee and nothing else, which might water it down. Is it really necessary for parties in commercial litigation who agree that there shall be a guarantee as substitute security to have to put in such additional wording in order to avoid falling into this trap, which Mr. Bedzhamov now finds himself in? In my submission, it should not be necessary to make it express, whether you do that as a matter of construction or as a matter of an implied term. And that's not the argument. But there's one additional point I wanted to make in relation to a point raised by my Lord Justice Nugee, where he said, you know, what if Standard Chartered decide not to pay? They must have thought it was worth something. And my learned friend, Mr. Georgy, replied in terms of what Standard Chartered could do in relation to UK sanctions as to whether in making the payment to Mr. Bedzhamov or in the court, they would or would not be subject to sanctions. But of course, the advisory note expressly includes other persons and purports to protect Standard Chartered if Credit Suisse, in particular, possibly A1, failed to perform, so that it becomes a completely open-ended debate. What my learned friend now accepts we have is something which at best exposes us to the chance of Standard Chartered trying not to pay, at worst, leads us to have to spend money in trying to enforce it, and at very worst, may lead to them persuading a court that in these circumstances, what their lawyers were advising as to the importance of this to protect them was in fact good law. And all of that is a million miles from the consent order that we were persuaded to enter into. So for a learned friend to say, you got what you bargained for, is simply not right. And that's not a matter of heartstrings, that's a matter of construing commercial parties agreeing what they will accept and not getting what they stipulated for. Unless I can assist you further, those are my submissions.
Thank you. So, well, thank you all for an interesting argument. We'll take time to consider our judgments. We'll hand them down in the usual way. You can sit down if you like for a moment, because this takes a bit longer these days. When you get the draft judgment, please let us have typographical but not substantive corrections. It's very important to understand the draft judgment is embargoed and confidential and is not to be provided to anybody except those persons that you inform the court you're going to provide it to, and they have it explained to them that if they publicise it, that's a contempt of court, which will likely result in sanctions, likely a contempt which would be punished by very severely nowadays. So that's important to understand. But you may use the draft judgment to try and agree an order and consequential directions and costs, and if you can't, we'll deal with all those matters in writing. Sorry it's such a lengthy homily these days, but we've had some rather bad experiences in recent times. So thank you both, thanks to your solicitors, and we'll deliver our judgments in due course.
All right.